Good evening, everyone. I am Mr. Abdullah, your host tonight, and we are going to discuss about the UK immigration law. I invited to the studio Mr. Jahid Chaudhary, who is a senior solicitor in England and Wales, who will be talking through the program and giving you more information about 7 years long residency, 10 years long residency, and 20 years long residency. Particularly, especially the immigration matter, he will be discussing and giving you as much as information he can throughout this program. So I would like to welcome Mr. Jahid Chaudhary, the senior solicitor, and Assalamu alaikum, sir. And everyone, you are watching the GMC TV. So here I would like to ask a few questions, Mr. Jahid Chaudhary, what he's thinking and what's the update, latest update, anything about the long residency program, long residency according to the UK immigration rules. Sir, would you like to give some information on discuss about the 7 years long residency, what exactly means to the common people, for the general people, for better understanding how they approach and what will be the best thing to do about the 7 years?
Thank you, Abdullah, for inviting me in this particular program. Today's topic is, of course, very important for immigrants with children, especially if we are talking about 7-year long residency, because the immigrants are from Pakistan, Bangladesh, Afghanistan, and other countries. So I would like to explain in both languages, so more people can take advantage, benefit from these programs. So first of all, you asked me to explain if someone is having a child or children in this country who have been or has been living in this country for a period of 7 years or more than 7 years. So what remedies are available for them to sort out their immigration issues? Very important. Yes. Before this 7 years long residency, it was actually a concession and Home Office policy that if your child has been living in this country for a period of 7 years, then your child is entitled to reside in this country. But and on that policy and concession, then there are many High Court and Supreme Court cases when they said yes, this 7-year residency make the child entitled to have a leave to remain in the United Kingdom. But then after these very big cases, the Home Office and the government actually introduced new legislation and introduced new immigration rules. So now any application which deals with the 7-year residency, that will be the application within immigration rule. So particular immigration rule 276 ADE, that's we called it. So whatever you mentioned in your introduction, that 7 years and 20 years, that particular immigration rule 276 AD that deal with these sort of issues. जैसा कि मैंने कहा कि बोथ लैंग्वेजेस में करूँगा ताकि ज़्यादातर लोग जो हैं वो उसको ये समझ सकें, तो मैं अभी इंग्लिश में ये बता रहा था कि ये जो 7 years रेजिडेंसी के ऊपर बच्चों की 7 year रेजिडेंसी के ऊपर जो इमिग्रेशन की एप्लीकेशंस होती हैं, अब वो इमिग्रेशन रूल के अंदर होती हैं. इससे पहले जो है ये कंसेशन होती थी, होम ऑफिस की पॉलिसी होती थी. होम ऑफिस ने पॉलिसी बनाई हुई थी कि अगर कोई बच्चा इस मुल्क में जो है वो 7 साल गुजार लेता है तो वो उसको फिर इस यहाँ पे रहने की इजाज़त दे देते थे. इसके ऊपर फिर हाई कोर्ट, सुप्रीम कोर्ट ने बहुत बड़े केसेस दिए कि नहीं, हाँ ये फिर बच्चे का राइट बन जाता है. फिर उसके बाद जो है वो हुकूमत ने, होम ऑफिस ने जो है वो नए इमिग्रेशन रूल्स जो हैं वो इंट्रोड्यूस कराए, और उसमें जो मैं पहले बताया था इमिग्रेशन रूल 276 AD जो है वो इंट्रोड्यूस कराया गया है. इसमें सबसे पहली जो बात ये है कि यू हैव टू प्रूव mean applicant has to prove that he has been living in this country for a period of 7 years at the date of application. So that is very important. If sometime people do make their application, they say, okay, once the Home Office will get their applications and they will decide the child will complete a 7-year residency. But most important is the wording of 276 AD is that at the date of application.
I have a question, sir. Sometimes people ask that, or probably you have been asked by the people as well, that which children will be considered within these immigration rules for the 7 years. The children were born in this country, or the children came to this country and then they spend their 7 years time. And
that's a very good question, and a lot of inquiries actually come to us. This question, particular question. Again, for your viewers and for ZMC network viewers, I would like to clarify this. Both kind of children can take a benefit of 276 AD 7-year residency. It means if a child born in this country and have completed has completed 7 years, then obviously that child is entitled to make that application. And if a child came in this country and from the date of arrival and date of application has completed 7 years, then obviously that child is also entitled to make that application.
So I have another question related to that. A child came to this country, we consider a child is age of under 16. So if anyone comes when he or she or the child is age of 14 or 15, just about a year to be 16, so still will I consider this 5 years? So then, because this child will be say if it comes at age of 15, then in 5 years, 7 years time will be
22.
So what will be their situation?
That's again that's very good question again. So law actually deal with all these sort of scenarios now. If definition of a child, first I have to say, if someone is under the age of 18 and under, okay, so that will be considered a child under immigration.
So that comes towards 7 years.
7 years.
Wow.
So if you are under 18 years of age, then you have to show that you have, like, child applicant has completed 7-year residency in the United Kingdom. Your question, if someone is over age of 18. No, this is the second band. If someone is between the age of 18 and 25, then that applicant, that child has to prove that he has completed half of his or her life in this country. So that is a difference. In first case, residency is a 7-year residency, and in other case, if you are over 18 and between 25, then you have to show this one, you have completed half of your life in this country. So that is that is a difference. Then obviously you have to show.
And would you like to give more information to the GMC TV viewers that in order to prove or show that someone has been living in this country along with their children, or children living in this country for 7 years, how they can prove this, what they need to do?
One very important thing is that people who are watching our program should understand this one. The burden of proof is on applicant. Whoever is making an application to Home Office, that applicant has to prove his or her case. Sometimes people say, if Home Office need anything, they will ask us. No, they will not ask us, because that's not their duty. That is the duty and responsibility of an applicant to provide all sort of evidence in support of his or her application. And now, your question is, Yes, you have to show this one. Yes, all these 7 years you were in this country, in the United Kingdom. And how you can prove? Obviously, if child is in school, the child can get a letter from school confirming that child is enrolled in that institution, and you can provide child progress report, a result card, a trip report, if child born in this country, birth certificate, and if child is registered with a surgery with GP, then obviously letter from a GP can confirm this one, that this child born in this country, registered with us, and attends our surgery. So these sort of all these sort of evidence, it's not there is no sort of a specified evidence in this one. Anything, any documents, even photographs, your photographs, you celebrated your birthday with your friends, obviously those photographs can also be produced. The rule of thumb is that you have to show all evidence which confirms that that child, the applicant, has been living in this country for a period of 7 years. So this is very important. So when you know, like obviously child doesn't understand the sort of immigration, the parents, they must realize it. Okay, look, if they are planning to make application for their child on a basis of child 7-year residency, then they have to prepare for this application right from the day one. Right from the day one, they must have a proper folder in which they collect everything, every piece of evidence which relates child 7-year residency in the United Kingdom. So that is very, very important.
Thank you so much, sir. I think the viewers will be very happy to know that they have a chance, once the children living in this country for 7 years period of time, they can make an application to be settled in a legal way. And what your opinion, or what's your suggestion for the people who has been living in this country 10 years, some of them, they are legally living in this country, lawfully living in this country for 10 years, and some of them, they made some application that got rejected or refused, but living in this country for 10 years. That's
but first I just want to add a few things in a 7-year residency. One, obviously, because as I told you, this is now the application within immigration rules and under Appendix FM, because that child will be called as a qualified child. So if you will make a good application, then you have good chances. Most likely you will get a visa for your child. One more question now people can ask this one: can we add ourselves as a parents on that child application? Yes, of course. The parents and the other siblings. If that child who has completed 7-year residency is having a more sibling, that those siblings and the parents can also be added on that application. But for the parents, they only need to show that they are having genuine and subsisting parental relationship with that qualifying child. So if obviously they can show this one, look, child is living with us, we are taking all decision about the upbringing of that particular qualifying child. We take that child to school, to park, to out of school courses, mosque, temples, any other extracurricular activities. So if parents can prove all this, then certainly the whole family can get advantage of this. And there is a mashhur there is a famous case on the one PD Sri Lanka which say this one, okay, yes, parents, if they prove that they have subsisting parental relationship, they should also be granted. And the Home Office normally now, I notice in my practice this one, normally Home Office give a visa to leave to remain to the entire family.
I have a question again. When I picked up the word, that when you said good chances,
yes.
So shall we still be feared that, oh, if I make an application, then like completed successfully 7 years, but making an application is there any chance that the application can get refused or rejected?
Nigeria, after that, chances of refusal are very slim now. But still, obviously, sometime Home Office, if the parents are having extremely bad convictions and other sort of things against them, then maybe Home Office can take some sort of adverse decision on that.
Parental activities can have impact.
Generally, in this case, Nigeria Supreme Court explains that no, they should not affect the kids, but Home Office can take. But as I told you, this one from our experience and from Home Office new policy guideline and Supreme Court decision in Nigeria, most likely the family will get the visa. Yeah.
Thank you.
And the second question, now we come to, okay, 10 years you have to divide this lawful residency and unlawful residency. If and then again, immigration rules, paragraph 276B, 276 AD that deal with 20 years and 7 years.
Okay.
276 B that deals with the 10 years lawful continuous residency. Two important factors we have to prove. Number one, you have been in this country lawfully for the period of 10 years, and that 10 years must be continue. When I say continue, this means there must not be any period during which you were out of or without any leave. So you must have leave all the time during these 10 years.
For the common people's understanding, for the JMC TV, the JMC network viewers, I'd like to get into more details for better understanding, for my understanding. If I say that during this 10 years period of time, I made an application and once or twice I get a refusal, I got refusal from the Home Office, and then I managed to get through the judicial review, and after that someone has appeal and they won the appeal, or someone has to do the appeal to the upper tribunal. So do you, what would you say towards them, that was there any break, or the judicial review somehow it covers is within the legal frame?
That's a very important question. Any time period which you will spend, like applicant will spend during the pendency of appeal in first year tribunal and upper tribunal, that will be counted towards your lawful residency. But if someone will apply for judicial review is not a immigration remedy, that we must understand. Judicial review is a civil remedy. So when people will make an application for judicial review, that will break their 10 years, that will break their continuity. So obviously the period which they will spend during the pendency of judicial review, that will not be counted towards the lawful residency.
Then if someone spent For example, judicial review is always lengthy process,
Yes.
and someone spent about 3 months or 4 months to get the result out of the judicial review, that their application is they can go ahead with the appeal, or the court said, oh, your judicial review or reconsideration has been accepted. So this period of time, that will they be that time will be considered within this 10 years lawfully, or still is a break?
Again, obviously, if
Because I'm asking for some people.
No, that's very important. Yeah. What happened when Home Office refuse your application
Yes.
without in-country right of appeal?
Yes.
Then obviously, if you want to keep your continuity, then you have to make a fresh application
Yes.
within 14 days.
Yes.
Okay. If you don't do this one, yes, you do have 3 months to lodge a judicial review. That's why I explained to
Yes.
you that, and for your viewers, that if you lodge the judicial review within 3 months, yes, you are entitled to lodge the judicial review, but that will break your continuity. So the period, obviously, because Home Office refused your application without in-country right of appeal, and now let's suppose at the end of your 3 months you lodge judicial review. So what was your status during these 2.5 months, or this period?
Yes.
You are without leave.
Yes.
So obviously Home Office will consider this as a break, as a break. Sometime what happened? I recently came across with few things. When people make an application for 276 under 276B, Home Office refuse for lack of they say no, there was a previous break, so you're not entitled. And when you lodge a judicial review, and your judicial review you got the permission, then what happened? Then you will get your leave under human rights.
So that's not the 10 years long residency.
Technically they will, Home Office will give you indefinite leave to remain under 276B, but your appeal most likely will be allowed on a human right grounds, not under 276B. So if your appeal will not be allowed under 276B, then you will get ILR, but they will actually use the discretion. But again, that may become a bit problems when that applicant will make an application for British citizenship, and they say, okay, look, during that period you were not having leave, and your appeal was allowed on a human rights ground, so we will not consider. So that's a bit like this one.
So what will be their suggestion for them, that they should make application for British citizenship after 12 months, or when they will be eligible to make British citizenship?
Yeah, I think we will do a full programs on this British citizenship, and then
Next
I will
time
explain. Explain
so this
to
is
your
interesting
viewers.
Thing that you will have to be with us for a long period of time. Then you will be able to know further more information. Now I'm moving on to the next stage, which is 20 years long residency, and the people living in this country. And some people, they made application, they lost appeal or judicial review. They got a period of stay or no stay, without valid leave. But they managed to stay in this country for the period of 20 years. And now, what can they get from the UKBI immigration rules?
Yeah, a few more things I want to add this one, because obviously in 276B, 10-year lawful residency, again, that application will be under the immigration rules, and then you have to meet all the requirement, and the other requirements that you have to pass life in UK
Life
test,
in the UK test.
and you have to pass a English language test.
I thought I finished the 7 years rule, so there is some more story. Okay, so life
Yeah.
in the UK test and English
Yes.
test.
Unless you are exempted
Unless you are exempted by passing university
university degree and
from
you
this
are
country
from
or any other country.
if you done a degree from any other country, then obviously you need a certificate from NARIC confirming this one your degree is equivalent to
Or passed in English.
or pass is English test, or you are like from English speaking countries, but obviously life in UK test you have to do that. So if you don't do this one, then obviously your application will be refused. So obviously if you are making application under 276B 10 years lawful continuous residency, then along with this residency you also need to prove other things, which is life in UK and English test.
Some people, they have difficulty, for example, before reaching this 10 years, they already made application which is pending. Like when they made application, it was 9 years or 8 years and a half. Now the passport and application, everything is with the Home Office. Can they take like English test or life in the UK test when the 10 years comes? Because if I, for example, I've been living in this country and I'm 10 years now, I've been living, and I want to take IELTS or English test and life in the UK test, but they will not allow me to sit in an exam without this passport. How should I go ahead with that?
Yeah, two things. One, I will suggest this one. Obviously, if your one application is already with the Home Office, and now you think that you have completed 10 years,
yes.
then more appropriate thing is to make a fresh application. But obviously, the question is, we want to pass the English language test and the life in UK. For that purpose, I will suggest to request the Home Office to send you a passport or a certified copy of that. Sometime Home Office send you the passport and you can use that one.
Oh, that's a good thing to know.
Yeah.
And can we go to the next?
20 years
yes,
one. Yes, so obviously 7 year, 10 years, and
Yes, now 20
and
years.
one thing I think we are missing. We discuss 10 years lawfully.
Yes.
But if you are
without
leave,
Yeah.
then obviously you do not fall under the category of 276B. Then obviously, along with this 20 years, I explain this one. So first, again, we come back to the immigration rules, paragraph 276 ADE. This says that if you have been in this country, if you are 25 or over, and you are you have been living in this country for a period of less than 20 years, then still you can make that application.
How can I do that? Because this rule says 20 years and
still, but in this case you have to prove that there are significant obstacle for you to reintegrate in your country of origin. This means if you can prove Home Office, look, these are the 1, 2, 3. These are the significant obstacle. Like those, there is no one for me to return to. I will have no food, no shelters, no properties. I have some enmities with the peoples. Maybe I married against the will of my parents, so they have disowned me. So you can, whatever your circumstances, you have to show Home Office, look, there are significant obstacles for me to reintegrate into my country. So if you can prove this one, then you can make this application even if you have not completed 10 years. But still you can make that application. But now we come back to 20 years now. So if you have been living in this country for a period of 20 years, whether lawful, unlawful, it doesn't matter. You only have to prove that you have been living in this country for a period of 20 years. But you have to prove this. So that is very important. Obviously, one thing, sometimes people say, oh, look, when I came this one, I have a passport, there is a stamp, and I came in this one. That is not sufficient evidence. You have to prove, again, 20 years continuously. That showing this one, you enter in this country, Home Office sometimes say, we don't know, you may left the country and then you came again. Okay, so that's again our responsibility. So every bit of evidence, paper, photographs which show you are in this country, the applicant should actually keep.
Some people, they don't keep records of anything, because they think, okay, if I put or use this address, Home Office may find us, and they don't go to GP because again it's a record. They don't have a bank account. What else documents they can provide?
They again, obviously, the most important thing is obviously the documents from some government sources like bank statement, GPs, and Inland Revenue. These sort of stuff. But if your question, if you don't have any primary evidence, then obviously you can rely on collaborative evidence. For example, if A is having a friend who is a settled person or British citizen, they say they both attended one programs when actually they came in this country, and they had pictures. Okay, so you can produce two things. You can produce that photograph saying, look, this is a man who can confirm that I have been living in this country for 20 years. Then you can produce a statement of that person. Yes, in these pictures I am along with this Mr. A and Mr. X, and I can confirm this one. And even if Home Office refuse, you can take that person to the court, and that person can. So that's why I've said this one. Whenever you go somewhere, if you are in this predicament and this scenario, just keep everything in a record. Sometimes you go for birthday, sometimes go the wedding ceremony, sometime you go even some festivals. So keep everything, because if you cannot prove, and there should not be, if you think like, look, I have this evidence, but I do have gap of these years, and then try to fill those gap, try to get the evidence, we called it collaborative evidence, so that you can show Home Office, look, I came in this country this year, and all relevant years evidence you must submit to Home Office. One important thing is, normally the people think that, okay, if we spend 20 years in this country, and after 20 years we will make an application, we will get indefinite leave to remain. No. After 20 years, it's a bit unfortunate. Long time you spent already 20 years, and now you will make an application. If Home Office grant you the leave, your leave will be for a period of 2.5 years. So this means you will be on a 10-year route. You have to complete another 10 years before you will get indefinite leave to remain. But obviously, for this sort of application, you don't need a life in UK, and you don't need a English test. You simply need to show this one. Again, I will say a 20-year long residency, that is a private life. Okay, I have now established a private life. Again, as a lawyer, I will suggest that, okay, don't only rely on your private life. Try to rely everything, your private life, your family life, and everything. So try to make a good application so that Home Office grant you, because you have already spent 20 years, which is a long period of life.
I have one more last question. The people who doesn't fall within these three categories, 7 years, 10 years, and 20 years, but living in this country with kind of exceptional situation, either got married or has a relationship with somebody and not married, but somehow they were at some point in a relationship, have a baby, and but they are not living together at the moment. Do you think they have a chance to make it?
Yes. For example, if someone was in a relationship previously, and they are having a child who is either a qualified child or a 7-year or a British child, and if that person is again having a genuine and subsisting parental relationship with that child, so that person is having a good chances to get a leave to remain.
How would I prove that I have a subsisting and genuine relationship as a father, because I'm already separated, or I'm a mother, I'm already separated from the father. Father is having the responsibility for the child.
Two aspects. Number one, obviously sometime although the parties are separated now, but they do come to a agreement. Okay, we can say this one contact agreement. You don't need to go to the court. If both parties can have an agreement together saying this one, okay, he is a father of my child, or she is a mother of my child, and she is allowed or he is allowed to see the child every week, twice or 3 times, can spend a time. So whatever the so we have to prove that that party is having a regular contact with that child. If contact agreement is not possible, then obviously you have to make an application to the family court to get a contact order. So if the court, normally if you are a biological father, and if the domestic violence issue is not involved, normally family courts also grant you contact order. So if you are having a court order, this person, father or mother, is entitled to have a contact with the child, then obviously Home Office will again grant you leave to remain in this country.
Thank you so much, sir, Mr. Zahid Chaudhary, and thank you viewers for watching and being with us, GMC Network, and we will come back again with new things. For example, Mr. Zahid Chaudhary also said that in the future someone he will discuss and give us more information about British citizenship, and hopefully we will get to know more about UK immigration rules and regulations, and the people from different countries, even the European nationals, more concerning about the Brexit and what's happening in their situation, the EU settlements, so some other like everything. I mean, briefly, if I said that the UK immigrations and EU regulations for the EU people or citizens who has been living in this country, we can come back another day with more information. And please keep watching JMC TV. And I would like to give you again big thanks for your patience and being with us for this long hours, and making out from your busy schedule and giving us some time. And we will highly appreciate if you keep watching GMC Network. And I'm Abdullah. I'll take a leave at the moment, and inviting you for the future event again. And thank you, sir, Mr. Zahid Chaudhary, for being with us and giving more information and highlighting the key points about the UK immigration rules, about the 7 years and 10 years and 20 years. Thank you so much, viewers, and have a nice time, and see you soon again. Thank you.